Hello, this is Matt on the Moon Family Sedan channel. Attorney Jeremy Hogan says watch out for a particular ruling which should be coming down the pike pretty darn soon. And it's consequential enough that he even said to Attorney John Deaton, quote, "Thank God you were in that hearing to force the issue," end quote. I'm going to share with you all the specifics, but regarding the SEC v. Ripple case, the most recent development, I'll give you the specifics on it, but the point being, there could be some very serious ramifications for the SEC v. Ripple case. So this is potentially particularly consequential if you are an XRP holder. I've got perspective from Attorney Hogan, Attorney John Deaton, and Attorney Bill Morgan, all members of the XRP community. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So here's what kicked it off. A couple tweets from the official library account right here, and they simply wrote the following. The last filing in our case is due today. The SEC is going to hate it. And then they have a little fingers crossed emoji. And then library says, when John Deaton and Jeremy Hogan read it, they are going to say we're geniuses or really dumb. And I can't speak to like whether or not it's a brilliant legal move or not, since I'm not a lawyer. I'm going to share with you again what a few of the attorneys within our community have to say here. But I will tell you that what they've done here, at least in terms of the timing of this, is outside of the ordinary. Also, I want to give a quick shout out and credit to Attorney James K. Filan for sharing this legal document, which I got a couple snippets I want to share with you. But I think the Crypto Basics summed it up pretty well with this article titled "Pro XRP Lawyers Say This SEC versus Library Ruling Might Affect Ripple Lawsuit." Pro XRP lawyers react as Library files a new motion in its case against the SEC. And by the way, I'll pause and note, this is not something that we knew was coming. This was out of the blue completely. But it's certainly necessary because, given that we're in the remedies portion here, you may recall that at the end of January with John Deaton having jumped in as amicus, he actually was able to get the judge to at least verbally commit to noting that any sort of ruling resulting in Library's loss would only apply to those transactions and not to the secondary market, which is crucial. And that's really what's at play here. So check this out. Piece reads as follows. Top cryptocurrency lawyers have been reacting to Library's latest motion filed in its ongoing lawsuit against the SEC. Earlier today, Library, a content sharing and publishing platform, filed its supplemental brief supporting its motion to limit the Securities and Exchange Commission's remedies in the SEC versus Library case. As part of its claims, Library asserted that it had been focused on getting clarity around using Library tokens, which is LBC for short, that's a little ticker symbol, from the SEC for years. However, the Commission refused to clarify the token while seeking a broad-based injunction that is neither specific nor clear. Although a summary judgment decision was made in favor of the Securities and Exchange Commission last year, Library asks the court, in its latest motion, to clarify that LBC secondary market transactions are not securities. I'm going to share with you just a small bit of what was shared in this brief. It's 7 pages. I'm not going to go through much of just the part that's highlighted on the screen here. So this is what Library wrote to the judge in that case. The Commission proposes a final judgment that would leave open the question of the scope of entities and individuals subject to the injunction. The Commission's proposed final judgment thus lacks the clarity required of an enforceable final judgment. The Commission's overly broad language leaves unresolved the crucial question, which the Commission put directly at issue, of whether Library's wholly owned subsidiary, Odyssey, or any other user of Library tokens would be subject to the injunction. To the extent this court were to issue an injunction, the language of the final judgment must make clear that, number one, only Library violated Section 5 by offering and selling pre-mined LBC, and that LBC tokens are not in and of themselves a security. And, number two, nothing in the injunction prohibits Odyssey or other users from using or purchasing LBC. Now, folks, doesn't that sound like what I and many others in the community have been saying is of the utmost importance in the SEC v. Ripple case? Because I've acknowledged ever since the beginning, Ripple could lose, and maybe if it's just a small loss, effectively, in some sort of technicality, they have to pay a fine, whatever. Say it is something along those lines. It's not going to matter for us, and the outcome can still absolutely be positive as long as there's a path forward for XRP. Well, the SEC wants all of that to be vague, and so this is library pushing back, saying, no, look what the SEC is doing. We have to have clarity. Well, it's the same issue at the core of what's going on in the SEC v. Ripple case. We as XRP holders, if we don't get that level of clarity, what do you think that's going to do to XRP markets in the United States, but also to whatever degree on a global scale, because that's going to be, the impacts would ripple out, if you will. But if there's not sufficient clarity, then exchanges won't feel comfortable bringing it back. So that'll be negative for any sort of XRP holder, any investor. And also, anybody that's interested in building on top of the XRP ledger, there'll be less activity, less volume. For certain projects, liquidity is of particular importance. It just depends on what you're doing with it. So the major fallout, depending on what exactly occurs here. But that's why this is being talked about now. So check this out. Attorney Jeremy Hogan shared a snippet also from that filing from Library, which reads as follows. Though the Commission is content to perpetuate uncertainty, Library submits that it is critical that the final judgment clearly state that 1, LBC is not a security in and of itself, and 2, Odyssey and LBC users are not subject to any permanent injunction that the court may order. So he's highlighting the same stuff here. And here's what Attorney Hogan had to say about that. He wrote, Library is asking the court to clarify that secondary sales of Library are not affected by the judgment. Watch out for this ruling, as this is a possible scenario in the Ripple case, with the SEC asking for a broad/vague injunction and Ripple seeking clarity from the judge. And folks, unfortunately, and he's absolutely right, that's what the SEC wants, as broad and vague as possible, so that they are held down to as little certainty and as little commitment as possible, so they just have flexibility when it comes to potential future lawsuits. It's disgusting, but that's how they're behaving here. And somebody named Hesher Ventures responded to Attorney Hogan and said, I know commenting on others' legal work is not a great ask, but does this motion strike you to be above the prowess or rigor of their original defense? I wonder if there was outside input whereby insights/strategy for this motion was put forth for Library defense to pick up. And Attorney Hogan did write back, and he said, the major question argument came out of nowhere. No doubt, it's not normal to be raising it for the first time here. So think about that. This is the first time that this particular issue has been raised specifically by Library, like this anyway. Not that they haven't talked about utility of coins or this or that, or brought up the concerns about users. They've talked about that stuff. But this exact argument, and fleshed out the way that it is here, yeah, this hasn't happened before. So Attorney Hogan is talking about the major questions doctrine, and just through a quick Google search, and I have talked about this on the channel before, from time to time it has come up over the course of the last 2.5 years. This is just a random site I came across called Open Casebook, and they wrote the following. The major questions doctrine holds that courts should not defer to agency statutory interpretations that concern questions of vast economic or political significance. The Supreme Court justifies this limitation with the non-delegation doctrine. According to the Supreme Court, courts are supposed to interpret major legal questions, not administrative bureaucrats. Now, folks, isn't this a major legal question? Doesn't it sound like that? This is the major questions doctrine. Because look at what's at play here. The health and viability of an entire burgeoning asset class that's only existed for 14 years. That's what's at stake here. And we're going to leave that to unelected bureaucrats? We're going to leave it to those little asshat pricks at the SEC? Or, since it's, as at Library's arguing here, it's a major questions doctrine, shouldn't the judge absolutely do his job and make clear? Now, the good news is, as I stated a little bit earlier in the video, the judge in that case has stated that he intends to, once this is all written up, indicate that secondary market transactions will not be a part of this, but I appreciate that Library is pushing back to try and ensure that this actually happens and being forceful about it. Somebody named Charlie wrote to Attorney Hogan and says, Jeremy Hogan, as a lawyer, you should know that the court does not have standing to make that ruling. The judge already knows that based on last ruling, highly unlikely judge changes opinion. So I'll just respectfully disagree. And again, I'm not pretending to be a lawyer or some sort of legal expert. I only play a lawyer all up on the YouTubes. But in the Googling that I've done over the last 2.5 years, anytime major questions doctrine comes up, just as a layperson here, just using common sense, it absolutely seems like the lawyer, or that the judge here, should be piping up. Attorney Hogan responded and seems to think along those lines as well. He said, a judge can rule on an issue not explicitly raised by the pleadings. Sua sponte, there's a legal term for it. Happens all the time, but should be done with caution. And so I appreciate the insight, and fine, do it with caution, of course. That's fine, but I'm just saying, if the major questions doctrine isn't at play here, where the hell is it at play? There's so much at stake for the entire asset class here. And so then Attorney Deaton retweeted what Attorney Hogan shared, and Attorney Deaton wrote, I have the transcript from the January 30th hearing wherein I appeared for Naomi Brockwell. The judge promised he would make clear his order did not apply to secondary market sales. I objected to the overbroad injunction language, and he said he would not issue an injunction like that. And so I certainly hope that the judge keeps his word. Thank God indeed that Attorney Deaton was there, as noted here by Attorney Hogan, because Attorney Hogan wrote to Deaton and said, thank God you were in that hearing to force the issue. Maybe we can disguise you as Attorney Solomon and sneak you into the Ripple hearing as well. Yeah, that would be nice. But it's true. The fact that the judge said what he said, and it was brought to his attention the way that it was, when we got to the remedy portions of the case, that's thanks to Attorney John Deaton. All the credit in the world. Absolutely. And so we are going to see that transcript. As soon as that comes out, I'm going to be covering that on my channel here. That I'm really looking forward to seeing it just specific. And we already know like the general content because John was talking about it back then. He just can't release it just yet. And then Attorney Deaton also said, I have to wait another few weeks before I can publish the hearing transcript, but I'm hoping the judge does what he said he would do and not do what he said he would not. So I'm optimistic because it would just be bizarre. The transcript, it's coming out for sure. If the judge goes back on what he promised in court that day, that ain't going to be a good look. I'll just say that. That will not be a good look. And here we have a perspective from Attorney Bill Morgan. He shared this part of what the library submitted, this legal filing, which reads as follows. Simply put, although the commission may have the specific authority to regulate and enforce the federal securities laws, it does not have the authority to independently shoehorn the 1940 Howey definition of an investment contract onto digital assets. Now that sure as hell is true. And here's what Attorney Morgan had to say. Thanks, James, and he's thanking James because he's also retweeting the filing which Attorney Filan shared. So he says, thanks, James. How bold, library raising the major questions doctrine at this late stage and arguing that the SEC can't shoehorn the Howey test stage to digital assets after the judge has made a decision applying the Howey test to LBC. Good appeal point argument. That is indeed interesting. And then he says, telling the court, in effect, it shouldn't impose relief. If the judge decides the SEC has congressional authority to regulate digital assets, it will not be helpful to Ripple and Coinbase, even though it wouldn't be a binding decision. Who's funding the appeal? Library is insolvent. Yeah, I was wondering that as well. Library is insolvent. What's that going to look like? And actually, we're like, how is this document paid for? I guess maybe they still have some scraps left. I don't know. But indeed, as it pertains to Ripple and Coinbase, other existing lawsuits out there, it's not this is good. It's not that this would be legally binding, but anything that's going to negatively sway potentially Judge Torres, I'm not exactly thrilled about that. You know what I'm saying here? So it's just interesting to think, and this is why Attorney Hogan was pointing this out. This is something that we as XRP holders may be absolutely staring at very shortly, depending on how things unfold. So just be ready for it in case it does happen. But I still think it's pretty damn clear that the asset itself is never the security, and justice tends to be done. In the United States, there's no perfect judicial system in existence, but typically what happens is whatever should be done typically is done. So I'm optimistic. We're not some sort of third world country. We're not some sort of banana republic over here. It's the United States. Again, not perfect. There's injustice that's done, but I am optimistic and I think for good reason here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.